What happens when a family member dies and they left a significant amount of debt and they didn't do any estate planning? Can creditors come after the surviving relatives to collect? Is an inheritance affected by that debt? Well, that's the topic of this video. Hello again, everyone. I'm attorney Robert Flesses. If you're new to this channel, now would be the best time to subscribe, because if you subscribe right now, you'll know where to go to get answers to your legal questions. When a family suffers a loss of a loved one, many times there's an issue of the decedent's debt. The survivors often ask if they'll become liable for that debt. Unless a family member entered into a contract as a co-borrower or a guarantor of the debt, then the answer is most likely no. But there's also the issue of inheritance that comes into play if the decedent had assets. When a decedent has assets and a lot of debt, that could affect the inheritance that could be received by the survivors. Let's say the deceased loved one had assets that are substantial. They owned a house with a mortgage and a car with a lien, and maybe even a vacation home. In this case, a probate estate will be opened in the state where the loved one resided, and any other state where any real estate is located. A personal representative will be appointed to manage the estate. Part of the duties of a personal representative are to inventory assets of the estate and notify creditors of the death. Creditors will have a fixed amount of time to submit their claims to the estate to see if they can collect, and if the claims are submitted, then the personal representative will have the responsibility to pay the debts from the assets of the estate. When a probate estate is opened, creditors have a very limited time period to file claims against the estate. If they miss the deadline, then their claim is barred. The time frame for filing a claim begins when a notice is placed in a newspaper or if the creditor is notified directly. Creditors for a deceased person's debt can't harass or intimidate relatives of the decedent. That's prohibited under the Federal Fair Debt Collection Practices Act. If there isn't any money available in the estate to pay creditors, then the creditors get nothing. There are also exempt and non-exempt assets which are not affected by a death. Retirement savings and life insurance policies are exempt in every state. Those assets can be distributed to beneficiaries without being subject to the deceased person's debt. So the most common situation where a relative would be responsible for a decedent's debt would be if they were a co-signer, co-borrower, or lived in a community property state. If there is a possible inheritance, you should seek the advice of a qualified attorney. I'm attorney Robert Flesses. Remember to subscribe, like, and share. Thanks for watching, and I'll see you in my next video.